Welcome to Careful Consideration of Our Common Concerns. I'm Dr. Ted Noel. In my last video on the election controversies, I said that I expected the suits regarding the election to reach the Supreme Court. And I never imagined what would happen. In fact, what happened was that Texas got there via a very unusual approach. What they did was sue several states for violating their own constitutions and violating the U.S. Constitution in the way they conducted the election. Now, this is really kind of interesting because if you look up here, you see they used Article 3 of the U.S. Constitution, which says that the judicial power of the United States shall be vested in one Supreme Court. That's Section 1 goes on, and then Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution, runs through a whole list of things, and to controversies between two or more states. Well, Texas sued 4 other states. That makes this a controversy between more than 2 states, so it makes the Supreme Court the court of what's known as original jurisdiction. They don't have to file it in a federal court, go through the appeal court, and then go up to the Supreme Court. This is filed as a case of original jurisdiction in the Supreme Court. Now, as I am talking here, the Supreme Court has placed this on the docket, but has not, to my knowledge, granted a writ of certiorari, which would say, yes, we're actually hearing the case. They have asked for briefs, and I know that Pennsylvania has sent one in, but let's take a look at what it is. Texas sued Georgia, Pennsylvania, Michigan, and Wisconsin. Notice who they did not sue. They did not sue Arizona or Nevada. The reason is simple. The Texas case is not about voter fraud. Keep that in mind. Voter fraud becomes an integral part of the case, but the case itself is not built on voter fraud. And as of last night, Texas was joined by 8 states: Arkansas, Florida, Louisiana, Mississippi, Alabama, Kentucky, North Carolina, South Carolina. So when we look at that, we now have a lawsuit that's involving 7 states against 4 states. And like I said, this is not a fraud complaint. Fraud's part of the deal, but it's not a fraud complaint. Because a fraud complaint would basically say, Pennsylvania just had a fraudulent election, and that election needs to be overturned. We need to, it was declared for Biden, and we need to switch it to Trump. That's the way fraud complaints work. And that's the way that the complaints by the president's legal team, by Lynn Wood and Sidney Powell, those are all constructed around fraud. This case is constructed about the law. And what they are saying is that the 4 states violated Article 2, Section 1 of the Constitution. And what it says is each state shall appoint, okay, they're doing it, in such manner as the legislature thereof may direct a number of electors. Okay? There is the key passage. That the legislature has the power to determine the way that the electors are chosen. In Iowa and Maine, for example, or is it Nebraska and Maine? I know in Maine, they're chosen, you have 2 at large, and then they have 2 congressional districts, and those 2 are apportioned by whoever won the district. So you can have 3 Democrat and 1 Republican elector, which I think is what happened this time. In any case, that's one way they can do it. Originally, most of the states simply had their legislature appoint the electors. Over time, it has drifted into a vote of the people. And when that happens, you end up with, for example, Florida was won by Trump. Ohio was won by Trump. California was won by Biden. New York was won by Biden. And all of the electors in that state go to that candidate. It's called a winner take all. Now, but notice what it is. All of this is as the legislature directs. And in each of these states, these changes have been made over time. Now, the complaint says that the direction of the legislature, notice it says the legislature, not the legislature plus the governor, not the legislature plus the Secretary of State. It says the legislature will define how we do it. And in all four of these states, we have major issues where certain things were done totally contrary to what the legislature directed. And the key here is that the violation had material results. And this is where fraud comes in. When you see what the violation does, the number of votes that were switched were significantly larger than the margin of victory. It's one thing to say we committed fraud because your college student who now lives in another state came in and voted at home. That's one person. Yes, it's a violation of the law. No, it's not material because one vote didn't determine the congressional election. But if we have 300,000 votes from people out of state or 300,000 votes that aren't real votes, that's material. Okay? And because these breaches of the Constitution and law are material, the results can compromise the election. And the Texas complaint basically says we can have no faith in the value of that election because of the problems that have come along. And then it goes on to point out that the legislatures can fix it. So let's look at the specifics real quick. The injury that they ask for remedy for is a state interest in a fair count in the Electoral College. Okay, they're not saying we're suing for a particular outcome. They're saying we're suing so that the Electoral College will be done fairly and properly according to law. The injury, in a sense, is to the law, but it's similar to the one-man, one-vote rule, which was put in place some years ago. And if you take it, it's one man, one vote. I vote for Biden, you vote for Trump, or vice versa. It doesn't really matter. Our votes cancel out. But ultimately, however many people vote, the candidate with the majority wins. And this brings up the point of what is a vote. A vote is a choice made by a qualified elector. That means I live in the state for the right number of time and this address for a certain amount of time, who have properly registered. I've properly registered. I can pull up my voter registration card here and show you, yes, I did everything that they wanted me to do. I'm properly registered. And I cast my vote in a timely manner, in the manner prescribed by the state legislature. So mine is a valid vote. Somebody who didn't meet those four requirements, qualified elector, properly registered, timely voted in a manner prescribed by the legislature. If that was not done, then what you have is an invalid vote or an unlawful or an illegal vote. And the whole issue of the franchise is casting legal votes. Well, the Democrats are screaming, you will disenfranchise all these voters. No. A ballot that was trucked in from out of state to be counted is not a vote. But that vote can disenfranchise a real voter in the state. So they're turning the argument on its head to say you're bad when in fact they're the ones doing exactly what they claimed that we should not do. And the point that Texas makes is that a proper count is essential to faith in the next election. It is a centerpiece of our system of government. Now, the keys here are violations resulted in large numbers of disputed ballots. The Supreme Court should enjoin the current electors. What that means is the current electors in those four states cannot vote. They're wiped out, at least temporarily. And then the legislatures can appoint electors. And in Bush v. Gore in 2000, the Supreme Court held that the state legislature has plenary authority. That means that the state legislature can do things in this that nobody can question. It can't come back to the Supreme Court and say, well, you didn't do it right. No. And this can go from anything. For example, Pennsylvania has both houses of its legislature held by Republicans. They could decide, well, we think it really went to Biden and send all of the votes to Biden. They could say, well, we're going to divide the baby and say 60 to Trump and 40 to Biden. 60-40. They have 20 votes, so it would be 12 and 8. So they have all of these choices on how they do it, and they have plenary authority, and it is very well established law that the legislature has that choice. Now let's look at specific states. Georgia. Georgia was sued by the Democrat Party of Georgia, the state was, and they had some small technical thing. The governor and Secretary of State, both Republicans in name, created a consent decree which gave the Democrats a pot full more than they asked for in changing the rules. Universal mail-in balloting, they changed the rules on checking signatures because every state has a signature match rule on absentee ballots. And the signature match rule was made impossible, so that in this election, the rejection rate went from 6% down to about 0.3%. It's almost a 20-to-1 change. And if you take a look at the number of mail-in ballots, that's more than enough to throw the election the other way. Okay? The issue is faith in the election. The second thing they got was this universal mail-in without requests. And in the universal mail-in ballot stuff, many people who weren't legitimate voters got ballots. Out-of-state people got ballots. I mean, you run the list. There's 1,000 different ways. All of those were contrary to Georgia law established by the legislature, which means that the consent decree in Georgia is presumptively invalid because it wasn't made by the legislature. The suit should have been thrown out because the governor and secretary of state did not have standing to change the rules. But the court allowed the suit to run, and those rhinos changed it. The last thing that Georgia did was they excluded a lot of observers in the Atlanta area, particularly. And the exclusion made it impossible to know whether a vote was valid or not. So ultimately, we have a number of votes, supposed votes, that are impossible to determine the value of. Are they real? Are they fake? And this casts the whole election in doubt. And you notice we're not going to the things such as Ware County, Georgia, where we found a machine flipped votes. We're just not going to those things because Texas isn't dealing with that. Texas is looking specifically at the legal issues. The next one is Pennsylvania. And in Pennsylvania, the governor and secretary of state sued the legislature. See, the governor wanted some changes, and the legislature said, no, we're not going to give you those changes. So they sued, and the Pennsylvania Supreme Court, which is packed with hard lefties, said, yeah, you can do it. However, just like Georgia, the Supreme Court forgot that they had no standing to make this change. Now, they've tried to argue that if you were going to argue with the change we made, you needed to do it within a certain length of time before the election. And since you waited till afterwards, it's what we call a laches. You've let it go, and now you no longer have a right to complain. The problem there is, and the Texas Attorney General makes this very clear, that laches does not apply. He hits his head on and says, look, this complaint could not become ripe until the evidence came out after November 3rd. So what they did in Pennsylvania violated Article 2, Section 1, which gives the legislature the power. It violated some elements of the Pennsylvania Constitution. If you want to dig in through those, you're welcome to read the complaint. All 154 pages, which I did read before I prepared this. They went to a universal mail-in without request, which was contrary to the state law. They issued a whole bunch of instructions on process, contrary to state law, and they excluded observers. They shut things down for 4 hours, then they came back with tons of votes. But the key thing on the law is they excluded observers, and in every state, observers are required to be present when the vote is counted, and they blocked them out. So once again, this put many times more than the margin of Biden victory in doubt and should be thrown out because of the illegalities in the way it was done. Not the numbers. The numbers simply make it so that we have materiality, that it's a material effect. It wasn't 3 college kids. It was 300,000 votes. Big difference. And of course, Michigan and Wisconsin used universal mail-in without requests. And they had instructions on process, and they excluded observers. So again, this is all Article 2. They violated the state law established by the legislature, never went anywhere else. So what do we have coming out of this? The suit does not ask for a decision on who won. Some of the other suits say, we want you to flip the election. That's going to be blatantly political, and as I said before, the Supreme Court isn't interested in that. So what they're going to do is say, we want a political choice. And Texas is very smart. You gave them 2 choices. First, send the election to the state legislatures. Let the legislators choose the slate of electors. And there are lots of legal reasons why they could do it even after the Electoral College supposedly votes on December 16. Because remember, there's only one constitutionally required date, and that is January 20, which is Inauguration Day. So there you have it. This is a suit I believe will be heard by the Supreme Court. Texas makes a very strong case that the law has been violated, that there is a real injury, and so now we have 9 states saying we have all been injured by failure of these 4 states to properly administer their elections according to the Constitution and their own state laws. This is a case where the Supreme Court gets an opportunity to rule on the law, not on the count, but on the law. The count merely supports the fact that the law violations are material. And once they do that, then they have a political option. Send it to the legislatures or look at the calendar and say they don't have time to meet. We're going to send it to the House of Representatives. Remember that the January 6th date, where the counting of the ballots is done in D.C., is according to Article 3 of the Federal Code, not the Constitution. And so it's 3 U.S.C. And if you want to go look that up, the Cornell Law has a nice review on all that. But that's statutory, and statutory can be overridden by the Supreme Court if they need to. The only constitutional date is January 20. So there you have it. That is a quick and dirty summary of 154 pages of lawsuit. Until next time, take a look at those links below. Join me on MeWe or on Parlay, the new non-censoring, non-tracking versions of Facebook and Twitter. But if you must use the old left-wing censoring versions, we're still on Facebook and at VidZet on Twitter. The message is what matters. I'm Dr. Ted Noel. Thanks for watching.